Joining us now to give insight into the next direction the case could be taking is legal expert Modidima Mannya. Mr. Mannya, good evening, and thank you very much for your time and for joining us tonight on In Focus. Before we move to where the trial could go now, the instances of withdrawing mid-trial, citing harassment of the court and the state prosecutor, is that something that is normal in our court of laws, and is that something that the courts take seriously?
Yes, and good evening to you and your viewers. Obviously, the court will take seriously the harassment of a legal practitioner handling a matter before that court. You'll remember that when Advocate Teffo was arrested in court, I think the court was not impressed, and I think the Chief Justice, if I'm not wrong, went as far as expressing his serious reservations about that. And I think that indicates to you the extent to which the court will take seriously the harassment of a legal practitioner. Having said that, though, I think since for a while now, there's been allegations of harassment, but I'm not sure whether there's been any evidence presented of the harassment that led to this withdrawal as matters stand. But you'll also note that there has been an allegation, a new allegation now that also implicates the president. So I think this is a bit more serious and warrants some bit of investigation.
Yeah. Is this grounds for even possibly the president bringing a case against Advocate Teffo for the kind of allegations that he's made publicly?
Yes, certainly. I mean, the same would apply to the minister and the commissioner of police who have been subjected to these allegations. One would ordinarily expect that if there were, in fact, a serious basis for this, either a criminal case would be opened or an order would be sought to interdict anybody who's harassing the other.
So, I mean, again, we were coming here with the view that we would have been hearing the two issues that were raised by Advocate Teffo before we went on the break, and he was supposed to have submitted heads of argument on these particular issues. And we hear from the prosecutors that he didn't submit heads of argument. The one issue is that two of his clients, 1 and 2, were forced to give testimony under duress on this particular matter. Number 2, 2 of the accused were in prison doing time at the time when Senzo Meyiwa was murdered. So where does this put those particular matters? Because heads of arguments were not brought on these. Therefore, even the other colleagues didn't then have to submit their heads of argument. So it's almost as if that matter is dead underwater.
Yes, it doesn't seem like the issue of the jurisdiction, which was always not grounded on anything, is going to be pursued. But you will recall that this was at the initiative of the defense for accused 1 to 4, that they wanted to argue an issue of jurisdiction. And the court then, in line with the law, afforded them an opportunity and outlined the process to be followed. And I think one must point out at this stage that I personally think that Judge Maumela has been very patient, has been very considerate and very accommodative. Under normal circumstances, these matters are brought by way of a formal application, which is a notice of motion supported by an affidavit, filed, served on the other side, afford them an opportunity to file their answering papers. Then you file your replying affidavit, then you file the heads of argument. And I think Judge Maumela decided that, look, let's shorten the process, file your heads, explain what are the issues. And the expectation was that today that was going to be the issue to be argued before court.
Yeah. Instead, we heard of another application in terms of Section 6B of the Criminal Procedure Act that Advocate Teffo had submitted representation to the NPA on July 4th. What does that actually mean?
Well, look, as I say, I think the difficulty in this matter has been that the normal procedures that any legal practitioner would follow to raise issues have not been followed. And I think that has been the concern. As you can see, even the letter that was handed in, and I think Advocate Malesela had indicated that she had not had sight of the letter. I mean, in litigation, you just don't stand up and say, I want to raise this issue. You have to give the other side a notice and an opportunity for them to prepare and to ventilate the matter so that the judge can make a decision based on having had both sides. Now, the issue of the representations were made after there was an order that the matter will be had today to debate the issue of the jurisdiction. And I think in the intervening period, as we understand, a letter was written to the National Director of Public Prosecutions to call upon her to withdraw the charges against the accused. And it doesn't seem that there has been a response. And if there was no response, the appropriate thing is to file a substantive application if there is a basis to compel either a response or a decision.
So in light of that substantive application not being filed, do we then assume that the defense actually had no case to start with, or is there something else at play?
Well, as I say, I think the disadvantage that the court and the colleagues there suffered was that issues are just raised from the bar without any notice, without any details of what is involved, and there's a demand for a full-blown argument. It never works that way. I mean, it just disadvantages everybody, including the court. Now, in real terms, in the many instances where these applications were brought, there was no substantive application. I mean, the judge really had no obligation to consider them. Hence, I said, and I'm not speaking for him, but I think he's been very considerate. I would love to appear before such a judge.
Advocate Malesela wanted, of course, clarity on the status of docket 375. We're currently still dealing with docket 636. That was part of what she wanted clarity on. Is that matter still on? Will it now be delayed by the fact that accused number 1 to 4 would need to get a new legal representation, who would need to then get the full document of the court, familiarize themselves with the processes and where we are at this point?
Yes, there are two issues. I think the clarity with this docket 375 has been provided. Whether that is satisfactory is another matter, and I think anybody who's dissatisfied with the explanation that is given can pursue whatever legal rights that they have, whether by way of bringing a review application to challenge the decision or taking some other action that they deem fit in law. With regard to the withdrawal, the accused have a right, fair trial rights, and that include the right to be legally represented. The court has an obligation to afford them that opportunity, and I think that's why the matter was postponed to the second, to make a determination of whether they have been able to get new legal representatives. Naturally, whoever comes on board, and I must remind that Advocate Teffo and his attorney took over from a set of lawyers, they would have to obtain all the documents, which are there, by the way, and I think Advocate Teffo and the other and his attorney will hand over those files to whoever takes over. They would have to study the matter and work out how much time they still need. They may be ready earlier. They may need some more time to consult and peruse all documents or request further documents. But that is the matter that I suppose will be dealt with once you have a new legal team on board. That is if the accused decide to engage new legal representative. They may decide to conduct their own defense, in which case I think the matter will proceed on that basis.
What does that mean? Does that mean Sergeant Thabo Mosia will then have to come back again to be cross-examined, and we start this process as if the last couple of months have not happened?
Yes, remember, Sergeant Mosia was still under cross-examination by Advocate Malesela, and the state prosecutors would still re-examine him. And I suppose if a new legal representative comes in and studies the record, they may feel that they would want to ask questions as well, despite the fact that Advocate Teffo had cross-examined. And I think they would request the court for that indulgence. And I don't see why the court would turn them down in regard to the circumstances.
Yeah. Mr. Mannya, just before we let you go, then one of the issues that we're hearing is Advocate Teffo saying, I am excusing myself from this case or withdrawing from this case and the court, but I will revert back to my position as watching brief for Senzo Meyiwa, brother to the late Senzo Meyiwa, with regards to docket 375. What does that then bring into this whole chronicle?
Well, I think that's the best confusion I've had for today after a very hectic day. I didn't understand what that means. Firstly, I'm a bit confused, and I'm sure maybe he's better placed to clarify this, that he says he was on watching brief on behalf of the Meyiwa family, but we also know that Advocate Nel is on brief on behalf of the Meyiwa family. What I do not understand, because I understand Advocate Nel to be dealing with the sisters, and it seems that Advocate Teffo is dealing with the brother. So maybe there's no convergence of ideas around what should happen. But beyond that, I find it a bit of a weird situation where there are people appearing before court, and I think Advocate Nel had said that he believes that the right accused are before court, except that he said he believes there's a mastermind. So he's not disputing the fact that the people before court are the right accused, except that there could be more with the mastermind involved. But then Advocate Teffo seems to hold a view that the four accused are actually not the right people who are supposed to be before court. And I think the statement issued or the views expressed by whoever in the Meyiwa family that they are not surprised makes this even more confusing, where you have the complainants, who's the family, somewhat having a direct interest in the people before court. Now, I keep on asking myself, what would happen if the accused who are before court are found guilty? Will the family say these are not the right people? And let's assume they are found guilty, and as part of the further investigation or process, the mastermind that we are told exists is found. Will it nullify the fact that these ones are guilty? So it's a bit of a confusing situation. I am not sure whether he's not finding himself in a conflict of interest situation. But more importantly, he has said that the court itself has been harassing him, and I'm curious to know how he's going to relate to the court now back as a watching brief. Also having regard to the fact that you must remember that Ms. Kelly Khumalo's attorney was in court and on watching brief, and it was on his objection that she ended up having to be excused from court. So it's going to be interesting going forward.
Mr. Mannya, I appreciate your time. Thanks for coming on. Legal expert Modidima Mannya there, helping us through a very confusing situation. Speaking of representation, legal representation of Ms. Kelly Khumalo, we'll speak to the representation of Ms. Kelly Khumalo in a moment to get a sense of where they find things now as they stand. Stay with us.